Yes,
My Lord, I can then turn very quickly to the last case, which is Hutchinson, and short submissions on the points my friend has made. It's in the Authorities, Volume 2. And it's tab 30. And you'll see that this was a statute providing power to make a bylaw for regulating the use of certain land conferred on the Secretary of State for Defence. And he'd made bylaws in relation to Greenham Common. And one bylaw provided that nobody could enter a protected area, and the defendants who weren't commoners entered the land. The Crown Court allowed their appeals, holding that the bylaws were ultra vires, and on appeal by the defendants allowing the appeals, the various paragraphs of bylaw 2, including bylaw 2b, were ultra vires, or in part ultra vires, as they stood, and that they contravened the proviso to section 14.1, which is set out above, that no bylaws shall take away or prejudicially affect any right of common. And then it sets out the test that in determining whether a legislative instrument that was bad in part might be severed, so as to be upheld and enforced in part, it was essential that the part to be upheld and enforced should be substantially severable, i.e. that the substance of what remained should be essentially unchanged in its legislative purpose, operation and effect.
Which page are you at, I'm sorry?
784, the head note.
Thank you.
In determining whether a legislative instrument that was bad in part might be severed so as to be upheld and enforced in part, it is essential that the part to be upheld and enforced should be substantially severable, i.e. that the substance of what remained should be essentially unchanged in its legislative purpose, operation and effect, that where textual severance was impossible and some modification would have to be made to the remaining text to make it grammatical and coherent, severance was only permissible only where no change would thereby be effected in the substantial purpose and effect, and that since bylaws drawn to permit free access to all parts of the land by commoners exercising their right would be totally different in character from the existing bylaws, the invalidity of 2b could not be cured by severance, and the defendants had been wrongly convicted. And then, if I can take your lordship to 802, page 802. And if your lordship looks at Lord Bridge of Harwich, my lord, these two appeals raise important questions as the test to be applied in determining whether delegated legislation which on its face exceeds the power conferred by the legislature may nevertheless be upheld and enforced by the courts, in part on the basis that the legislation is divisible into good and bad parts, and that the good is independent of and untainted by the bad part. And we say, if on this hypothesis I've failed on all my 3 points, if the provisions, including the words "all the Republic of Ireland," constitute unlawful discrimination, then we say it's delegated legislation which on its face exceeds the power conferred by the legislature, because it makes arrangements in relation to Ireland which are unlawful. And the question then is whether they can be divided into the good and the bad and the bad severed. My lord, if you go to page 809, your lordship sees the discussions on severance just below letter B. I'm not going to read it all out. It says our attention has been drawn to a number of the more recent authorities on severance. And then just below letter F, you have the citation from Lord Justice Ormrod. If the enactment with the invalid portion omitted so radically or substantially different to law as to the subject matter dealt with by what remained from it would be with the omitted portions forming part of it, as to warrant a belief that the legislative body intended it as a whole only, or in other words, to warrant a belief that if all could not be carried into effect, the legislative body would not have enacted the remainder independently, then the whole must be failed. And then there's the well-known quotation from Lord Justice Ormrod coming next. we respectfully agree with and adopt the statement of the law, it would be difficult to imagine a clearer example than the present case of a law which the legislative body would have enacted independently of the offending portion and which is so little affected by eliminating the invalid portion. This is clearly therefore an order which the court should not strive officiously to kill to any greater extent than it is compelled to do so. And then there are more observations made. And then the ratio of the House of Lords is at 811D. The test of textual severability has the great merit of simplicity and certainty. When it is satisfied, the court can readily see whether the omission from the legislative text of so much as exceeds the lawmaker's power leaves in place a valid text which is capable of operating and was evidently intended to operate independently of the invalid text. But I have reached the conclusion, though not without hesitation, that a rigid insistence that the test of textual severability must always be satisfied if a provision is to be upheld and enforced as partially valid will in some cases have the unreasonable consequences of defeating subordinate legislation of which the substantial purpose and effect was clearly within the lawmaker's power, when by some oversight or misapprehension of the scope of that power, the text as written has a range of application which exceeds that scope. It is important, however, that in all cases an appropriate test of substantial severability should be applied. When textual severance is possible, the test of substantial severability will be satisfied when the valid text is unaffected by and independent of the invalid. The law which the court may then uphold and enforce is the very law which the legislature has enacted, not a different law. But when the court must modify the text in order to achieve severance, this can only be done when the court is satisfied that it is in affecting no change in the substantial purpose.
I think you can really stop there, can't you?
And I can stop there, yes. Going back to this legislation, my lord, at tab 9, the Secretary of State has exercised statutory power. On this hypothesis, he has included provisions for the Republic of Ireland which lead to unlawful discrimination. The Parliament did not intend the Secretary of State to include in the legislation unlawful parts or unlawful discrimination. The scope of the power, therefore, in its application, includes things which it should not include. It is textually severable by striking out the words "or the Republic of Ireland" in the three places where it appears in 2.1 and 2.2. I think it's 3, it may be 4. But wherever the words "or the Republic of Ireland" appear, they can be struck out and they are textually severable. They are clearly substantially severable because in my submission, for the reasons I gave before lunch, it is obvious that the government would have made these regulations to protect the Exchequer for the reasons I've given, and if they couldn't have Ireland in them, they would have been made without Ireland. And indeed, that was the original drafting of the original ones dealing with habitual residence. If I can deal with the points that my friend puts in his case, and he makes a number of points against me at paragraph 171 of his case. It starts at 170 on page 35. The appellant submits first that severance is not in principle available here. He says the acceptance of the appellant's contentions based on the discrimination in favour of Irish nationals does not involve a finding that Regulation 2.2 exceeded the power conferred upon the legislature. Well, in my submission, that simply can't be correct. Parliament can't have intended the Secretary of State to make regulations that fend against community law. Parliament didn't intend to allow the Secretary of State to make regulations relating to the Republic of Ireland if that was unlawful. They clearly do exceed the scope of the power. And if it's unlawful to make regulations providing for favourable treatment for those habitually resident in Ireland, then he has exceeded his powers. Next, the appellant says that Regulation 140871 does not call into question the effect of Regulation 2.2. She says that in some way the court is applying Article 3. Well, again, with the very greatest respect, I simply don't understand that. Article 3 says there can't be indirect discrimination. There can't be unlawful discrimination. If there is unlawful discrimination, then it is unlawful. And once you come to the conclusion that there has been unlawful treatment or an unlawful provision made, then that offending provision should not have been made and should be severed. The Secretary of State isn't allowed to make provisions providing for unlawful treatment, and if he has done, those regulations should be severed if they can be. Next, the appellant says at 177 that it follows that Article 3.1 of Regulation 1408/71 does not empower the court to alter or amend the terms of Regulation 2. But with respect, this is nothing about what Article 3 of the EU regulation does by way of a power to alter or amend. This is the straightforward power of a domestic court exercising domestic law powers. And the laws I've just shown you in Hutchinson is, and it applies to cases purely domestic law or cases with an EU dimension, where you exercise statutory powers and you make English and Welsh delegated legislation, and where parts of it are bad, then the court can strike it out. It's nothing to do with what the European law provides power to do. It's all to do with domestic law. And it's a very simple principle. Thou shalt not strive officiously to keep alive, but you don't kill unless you have to. It's domestic law. And then finally, no, I think that was his last point, actually. Yes. So
well,
we say
he's accepting Parliament can do it, but he's saying the court.
Well, yes, I don't understand that actually either. I mean, the point is that concession, in effect, realises that this is domestic law and will be dealt with in accordance with domestic law rules. Parliament can unmake it. Indeed, I would assume that he would say Parliament has to unmake it, because, or the Secretary of State presumably has to unmake it, because the Secretary of State has included something that is unlawful. But the answer is you would strike it down. Or here, because it's part, sever it. It's simply the normal position when you have an exercise of statutory power and you include in the exercise of statutory power, or in the regulations made in the exercise of statutory power, parts which are bad and parts which are good. The parts being bad because they are not within the permitted scope of the Parent Act, for whatever reason, then wherever possible, you sever them. And here you just sever the words or the Republic of Ireland. So the starting point is, this is all about Mrs. Patmalniece, and the real question is whether the refusal of benefit in her case is lawful. And insofar as they say, oh, well, you can't justify the rules for Latvians because you do let the British and the Irish have it, and you can't let the Irish have it because that just shows you there's no problem. The starting point is, no, the situations are different. Ireland and Britain can be treated in one way because they are different from the other 25 member states, and that's the end of this point. But if you have to go any further, we say that treatment is either permissible under the protocol, or if it's not, and is indirectly discriminatory, subjectively justifiable. But if all of that is wrong, then in an appropriate case, you would sever the regulations. But none of that will assist Mrs. Patmalniece, who comes from Latvia, not from the Republic. So those are my submissions on that issue. And the summary, therefore, is we say the requirements don't give rise to direct discrimination on the first issue. We say that the true requirement is in Great Britain. If you look at in Great Britain, or if you look at the right to reside, it's not direct, it's indirect for the reasons I gave. Because it's indirect, people are more likely to satisfy it if they're UK nationals than EU nationals. They have to be objectively justified. They are based on considerations of economic and social integration, which apply across the board to all people and are justifiable, consistent with the EU law, accepted in Zaleska, consistent if necessary to go that far with Troiani, and finally the position in relation to Ireland does not undermine that justification. So unless I could assist your lordships or your ladyship further, those would be my submissions.
Thank you very much, Mr. Lewis. Mr. Coppell, do you wish to add anything? No, Mr. Cox. And you'll bear in mind this is a reply, not a first speech.
My Lord, yes. Can I deal with two matters in reply, and any other matters that your lordships or my ladyship will wish me to deal with? Firstly, is there direct discrimination here? And secondly, is there justification independent of nationality? And those issues arise, we say, from the common grounds that's set out in the Statement of Facts and Issues. And if I could just take your lordships back to that, page 10. Because in my submission, a lot of the argument that we've heard has been misdirected to issues that do not arise. Now, page 10, two matters in particular, or three matters in particular, are agreed. Paragraph 23, it's accepted that the appellant falls within the personal scope of Regulation 1408/71. She is an employed person. 25, it's accepted that Article 3.1 prohibits discrimination on nationality grounds in respect of the conditions of the appellant's entitlement to state pension credit. And 26, it is accepted that Article 3.1 does not prohibit indirect discrimination, which is justified by considerations independent of the nationality of the persons concerned. And in my submission, what the Secretary of State needs to show you is two things. Firstly, that the discrimination is not direct. And secondly, that it is justified by considerations independent of the nationality of the persons concerned. If he does that, he's home on the British citizen point. And I don't propose to repeat my submissions on the Irish citizen point. He doesn't need proportionality. We haven't argued that if the justification advanced is independent of nationality, that it is that a question of disproportionality arises. If he doesn't manage to show both those points, it doesn't help him to show that the measures he's taken would be proportionate to the discriminatory aim, or that in some way the measures would be proportionate if justification of direct discrimination were allowed. We say that his case fails if he can't show both those points and succeeds at least on the British citizens if he can. Now, he said towards the end of his submissions, my own friend said towards the end of his submissions, there was no magic in the personal scope argument. Well, in my submission, there is an element of magic in the personal scope argument. The claims in Abdirahman, Kaczmarek and Zalewska about discrimination all failed because in those cases the courts held that those persons were outside the personal scope of the discrimination provisions upon which they were relying. Now, we don't challenge the correctness of those findings on personal scope. But that is why those three claims failed. It was not because it was held that there was no discrimination, and it was not because it was held that the discrimination was independent of the nationality of the persons concerned. It was because none of those persons were held to be protected from discrimination by the provisions upon which they relied. Abdirahman and Kaczmarek, reliance upon Article 12 of the treaty, and in Zalewska, reliance upon Article 7.2 of Regulation 1612/68. None of those people relied upon Regulation 1408/71. We don't know why, but they didn't, and therefore the courts were not confronted with persons who were protected from discrimination. In contrast, Mr. Trojani and Ms. Martinez-Sala both did fall within the personal scope of the provisions upon which they relied, and that's why they won, because those measures were directly discriminatory, and nobody sought to argue that they were justified by considerations independent of the nationality of the persons concerned.
Which two won?
Trojani and Martinez-Sala.
And you say they won why?
Because they were within the scope of the provisions concerned, and the discrimination was direct. My Lords, turning then to the detail of why I say there is direct discrimination here, and I've put on your desks, or have put on your desks, a copy from the Supreme Court's website of a speech by my Lord Walker, which I'm afraid was only drawn to our attention, and we only appreciated its existence overnight. The document that looks like that, it's headed treated like cases alike and unlike cases differently, and it's a speech that my Lord Walker gave to the University of Victoria in Wellington in August of this year. And I just want to mention a couple of passages from it, if I may. I think it deals primarily with the issue of European Convention of Human Rights law and some of the what we would say were relatively underdeveloped aspects of their discrimination jurisprudence. I wanted to just refer your lordships to page 3, in which my Lord Walker asked the question, why cannot the topic, and that's the topic of what is direct or indirect discrimination, be left to the intuitive decency and common sense of the right-thinking citizen? The answer may be that intuition and common sense are sufficient in clear cases, but cannot by themselves provide the answer in marginal cases. Marginal cases include, but are not restricted to, those on the margin of direct and indirect discrimination. The distinction between direct and indirect discrimination is long established and important in UK anti-discrimination statutes, having got there initially from United States jurisprudence and having developed under the influence of European Union employment law. Under our national law, indirect discrimination may be justifiable, but direct discrimination never can be. There's a footnote with a reference to my Lady Hale's speech in the JFS case. And then my Lord Walker deals with the jurisprudence of the Court of Human Rights. And if I could ask your lordships to turn to page 14. Explains at page 14 that the Roma rights case can be analysed in terms of the fourth element in the model, that is, being in an analogous situation. If the claimant or complainant is not in an analogous situation to the actual or notional comparator, there will be no unlawful discrimination. But in deciding that question, the court may not rely on the very ground complained of as a reason for concluding that the situations are not analogous. And then he cites from the speech of my Lady Hale, a little further down in AL Serbia, in which my respectful submission would be that my Lady Hale explains the policy rationale behind the distinction, which is that it would be no answer to a claim of sex discrimination to say that a man and a woman are not in an analogous situation because one can get pregnant and the other cannot. That is something that neither can be expected to change. That, in my submission, is the policy rationale behind concepts such as direct discrimination. Can I then turn to why I say that there is direct discrimination here? And I just ask your lordships to pick up my learned friend's list of persons who do and don't, who do qualify under the amended test. And I won't take your lordships through it. There are a number of caveats that could be entered about the difficult scope of it, but I accept that it's a broad and useful outline. But the reason that I take your lordships to it is to ask your lordships to note that only two of the categories can be met simply by possession of nationality. And they are 6'9" and 6'11", British citizens and Irish nationals. They're the only two categories who qualify by virtue of nationality. That's why, in short, there's direct discrimination here. European Union citizens can't qualify just by being European Union citizens. Now, just to elaborate that, if I may, a little, and in my submission, it's a very important point, because my learned friend doesn't say that there's a different test under European Union law for nationality discrimination. All sides have proceeded on the basis that these concepts are the same in European Union law for sex and for race, and no one has suggested that the approach should be different under European Union law from that of national law. So what your lordships say about direct discrimination in this case will have ramifications across the whole field of discrimination law. We say that direct discrimination arises where the benefit is denied because of the nationality or the sex or the race of the claimant concerned. To put it another way, we would suggest that the but-for test that Eleanor Sharpston mentioned, that Advocate General Sharpston mentions, is the right one. But for the nationality or race or sex of being the wrong kind, would the claimant have succeeded? And I'll take your lordships to the cases, but your lordships are familiar with the facts. If Mr. James, when he went to the swimming pool, had been a 62-year-old woman and not a 62-year-old man, he would have got free swimming. If the black voter refused registration because he failed the literacy test, had been a white voter, he would have got the right to vote. If Mrs. Patmalniece were British, she would be getting state pension credit, even if she'd lived and worked for 40 years as a school dinner lady in Latvia And even if she'd come here and been for 10 years an asylum seeker, and someone thought not to be lawfully present because nobody appreciated that she was British. If it turns out that she's British, she gets home, simply because she's British. It's the only reason that she failed. Now, another way of comparing it is, as I've just suggested, is that is to look at the comparator. And the comparator must be identical in all material respects, save for the characteristic at issue. And so Mr. James's comparator was his wife because she was, in all material respects, the same as him. She was the same age, except she was a woman. Mrs. Patmalniece's comparator is a British citizen. And Mr. Lewis doesn't accept any of what I've just said. He says that direct discrimination only exists where certain additional matters apply, and he puts it in various different ways. So firstly, the way that he seemed to put it this way towards the end of his submissions, that all persons of the nationality of the claimants must be refused the benefit. And that because some European Union citizens have a right to reside, for example, they're economically active or have been, or family members of someone who's been economically active or has been, that it's indirect. And we say that's simply wrong in principle. Of course, that blanket discrimination is one of the categories of direct discrimination, but that is not a requirement for direct discrimination. Mrs. Patmalniece is complaining about discrimination on nationality grounds. She's not to be compared to a Latvian national who's been economically active. She's not complaining about economic discrimination. And by way of similar analogy, in the James case, it was direct discrimination, even though lots of men could get free swimming. All they had to be was 65. One only omits that if one zooms in about the comparators, and then when one comes out of it, forgets that there are classes either side who could benefit. And in fact, James was in some respects a weaker case because some women could be refused free swimming, whereas there are no British citizens who can be refused the right to reside. So one has to bear in mind the correct comparator. The second way that we understand my own friend to put it is that a requirement like the right to reside does impose a burden on own nationals, and therefore it's not direct discrimination. But when asked what the burden was, he said that they must show their passports. Well, Mrs. Patmalniece would have to show her passport to show she's a Latvian citizen, but that wouldn't be enough. She then also needs to show that she's been economically active. That's what the British and Irish citizens don't need to do. That's the problem. So the white and the black would-be voters both have to show their face to show the colour. The woman and the white would be the woman and the man would be free swimmers, both need to show their sex. Mrs. James needed to show she was a woman to get free swimming, but that wasn't the problem. The problem was that having both shown their respective sexes, one of them was refused because he was a man. Having shown their respective nationalities, Miss Patmalniece is refused because she's Latvian. And as we understand it, the third way in which the case is put is that if the requirements of the benefit include other non-directly discriminatory requirements, that one must lump them together, and that changes the character of the directly discriminatory requirement to one of indirect discrimination. And we also say that that's wrong in principle. I showed your lordships the case of Hoekx, H-O-E-C-K-X. I showed your lordships the case of Frilly, which I say authority that any additional ground which leads to the failure and which is directly discriminatory means that the test is directly discriminatory. Would James and Eastleigh have been different if, as well as showing that the person was a pensioner, they also had to show they were residents of the borough of Eastleigh? Would that have made a difference if they were both residents of the borough of Eastleigh? Could Eastleigh have lumped them together and said it's not really directly discriminatory? Look, we've got lots of requirements here. Would Decker, which I'll take your lordships to, about the pregnant woman, refuse the job because she was pregnant? Would that have been different if, in addition, there'd been a medical examination to show fitness to work, which she'd passed, just like Miss Patmalniece passed the habitual residence test? Would her employers have been able to say, oh, it's part of really the same thing. It's all part of a wider test. Look at our medical test. Some men can fail that. Forget about the fact that they can't fail the pregnancy test. My submission, it wouldn't make any difference. There is a habitual residence requirement. There is a requirement to that extent of social and economic integration. We take no issue with it. We passed it. What we take issue with is the additional requirement of the right to reside. That's a sine qua non for the entitlement to benefit. That's not disputed. Mr. Lewis doesn't identify any person who can get the benefit without having a right to reside. Everyone needs it. British people get it by having a passport. Irish people get it by having a passport. Latvians only get it by being economically active, or having been economically active, or being a family member of someone who's been economically active. Now, as I say, the Secretary of State doesn't argue there's anything special about direct discrimination on nationality grounds, or anything special about a European Union law, which requires this radically narrow understanding of direct discrimination to be taken. He's content, embraced my example of voter registration. He said it was indirect, because the black voters needed to show their face. If he's right, it turns 20 years of discrimination law on its head. He's not right. I just want to take your lordships to two cases that I've mentioned. First of all, James, which your lordships were taken to briefly. That's at volume 2, tab 32. If I could ask your lordships to turn to page 762. And in the speech of Lord Bridge, which I didn't take your lordships to, I took your lordships before simply to short points that Lord Acton made, though he of course agreed with Lord Bridge. We see at letter D, it had been common ground in the county court that the concession offered by the council to persons of pensionable age was discriminatory in favour of women and against men. But the Court of Appeal held that the council's less favourable treatment of a man than a woman was not on ground of his sex, that there had accordingly been no direct discrimination. And then they explained the condition, and they set out the text of the Sex Discrimination Act in relation to indirect discrimination. Turning towards the bottom of the page, in the reasoning of the Vice-Chancellor, just below H, last two lines. Moreover, the condition which had to be satisfied in order to qualify for free swimming did not refer expressly to sex at all. The condition was simply that the applicant had to be of pensionable age. The undoubtedly discriminatory effect of that condition only emerges when one gets to the next question, i.e. at what age do men and women become pensionable? The question is whether the council's policy amounts to direct discrimination on the grounds of his sex within section 11A, or indirect discrimination within section 11B by reasons of the council having imposed a condition on men and women alike with which a considerably smaller proportion of men than women can comply. Mr. Lester for the plaintiff forcefully submitted that there is direct discrimination in this case. He submitted that discrimination is on the ground of sex within section 11A if the sex of the plaintiff is a substantial cause of the less favourable treatment. In this context, he says, the correct question is, what would the position have been but for the sex of the plaintiff? The position would be different if the plaintiff's sex were different. That is direct discrimination. And that's the proposition that the majority of the court accepted. We see that at the bottom in the reasoning of Lord Bridge at H. The fallacy, with all respect, which underlies and vitiates this reasoning is a failure to recognise that the statutory pensionable age, being fixed at 60 for women and 65 for men, is itself a criterion which directly discriminates between men and women, in that it treats women more favourably than men on the ground of their sex. This was readily conceded by Mr. Beloff and is indeed self-evident. It follows inevitably that any other differential treatment of men and women which adopts the same criterion must equally involve discrimination on the grounds of sex. As Mr. Beloff was again constrained to concede, the council would certainly have discriminated directly in favour of men and against men on the ground of their sex if they had expressly made the concession of free entry to the swimming pool available to women aged 60 and to men aged 65. Now, my submission, if Mr. Lewis is right, that concession was wrongly made and wrongly accepted because some men got free swimming. That meant it was indirect discrimination, capable of justification. My submission, unless your lordships are able, and you've certainly not been invited to distinguish European community law principles of direct discrimination on grounds of nationality from British law principles and British law statute, direct discrimination on grounds of sex, then your lordships are bound by this. Lordship's certainly bound to hold this in relation to sex. There's been no suggestion of a different approach. There's been no argument, for a different approach to direct discrimination on grounds of nationality. Now, if your Lordships would just keep this judgment open for a moment, I just want to mention what I say is the error that underlies Mr. Lewis's reasoning. The error is to read the language of the test for indirect discrimination in isolation from the language of the test for direct discrimination. It is, of course, possible, if one forgets about direct discrimination, to go into the language that the Court of Justice adopts, look at what's said about indirect discrimination, and say, well, that's what we've got here. But in my submission, what one has to do where direct discrimination is raised is to take that issue first. And that's what Lord Bridge said in James, over the page at 766. In the first full paragraph, the question of indirect discrimination under section 11B arises only where the requirement or condition applied by the alleged discriminator to a person of one sex is applied by him equally to a person of the other sex. Pensionable age cannot be regarded as a requirement or condition which is applied equally to persons of either sex, precisely because it is itself discriminatory between the sexes. Whether or not the proportion of men of pensionable age resorting to the council swimming pool was smaller than the proportion of women of pensionable age was quite irrelevant. Women were being treated more favourably than men because they attained the age to qualify for free admission 5 years earlier than men. Now, so I would respectfully agree with what Advocate General Sharpston said in Bressel about the scheme that one must approach where direct discrimination is argued. And in my submission, that's the part of, that may be the explanation for the Court of Justice's approach in Bressel. We understand from Mr. Lewis that in Bidar no one raised the question of indirect discrimination. Well, in Bressel, in my submission, it wasn't in the interests of Mr. Bressel and his cohort to argue for direct discrimination because they had failed the indirectly discriminatory requirement of principal residence. If I could just ask your Lordships to go to the Bressel judgment. Is in volume 6. So I'm so sorry, volume 4.
Yeah, so you want to just keep James available still, or we finish with James?
No, I'm so sorry. Your Lordships can close.
We can put that away, thank you. So, volume 6.
Now we already have volume 4. I'm so sorry.
Oh.
Volume 4, tab 48.
48.
The proposition is it wasn't in his interest to argue direct discrimination because why?
Because there were two requirements, because accepting Advocate General Sharpston's analysis in Bressel, there were two requirements. There was a principal residence in Belgium requirement, like our habitual residence requirement, which was indirectly discriminatory because a Belgian national could fail it. And then there was a second hurdle, or at least there was a second set of 8 alternative hurdles, one of which every Belgian national could get over, namely having a right of permanent residence in Belgium, but which some European Union citizens might fall at. That, according to her analysis, was direct discrimination, and according to ours as well. Now, if I've got to get over both of those, I've got a litigation advantage if I wrap them all up in the same box and say to the court, yes, of course it's indirect discrimination, and look at this aspect of it. Look how discriminatory that is. How can that be? How can this whole test be justified in that way? So Mr. Bressel and his fellow would-be students had no interest in adopting Advocate General's the Advocate General's analysis, because while it made it easier for them to get over one hurdle, it made it harder for them to get over the other. Now, I haven't got that problem, because I've already got over habitual residence. I haven't got any interest in wrapping it all up together. In my case, it switches to my opponent who has the interest in wrapping it up together. But in my submission, that may well be the explanation as to why none of the parties argued it in Bressel. And I stand by what I said in opening, and I just want to take your Lordships to the the holdings in Bressol at 603.
It is quite interesting, though, that although the Advocate General went into the thing in some depth, the court just simply didn't pick it up at all.
I think, with respect, I would adopt the way my Lord's vernacular phrasing of it. They didn't pick it up, they left it sitting on the table.
Yeah.
That they neither rejected it nor accepted it. They said nothing about it. Mm-hmm. And they're very careful in my submission in framing their answer. And I accept that my own friend's point, I'm not sure it's just politesse, and they can be rather gnomic in the way that they deal with things. They have not picked up her challenge. They have not said whether the discrimination in question is direct or indirect. What they have said is it is indirect.
Even though she said there's an issue which the court couldn't avoid.
Even though she says it's an issue which the court couldn't avoid, the court has proved her wrong. They have avoided it. And if one lumps them together, of course they're indirect. What the court didn't refuse to do was to slice them. Now, my learned friends suggest that that's a hint that maybe one doesn't slice residence tests. But I've shown you, Lordship, the cases where residence tests were sliced. So it may be that the court has another rationale for it, another legitimating factor, which is that none of the parties asked them to accept that there was direct, that there were two distinct considerations, one of which was direct and the other of which was indirect. And so we see in my submission at 603, and if we can just go to because great reliance is placed on it at 47, as stated in paragraph 41 of the present judgment.
Sorry, we're looking at 47.
603 and para 47. As stated in 41 of the present judgment, and then there's a recitation of the principle of indirect discrimination, and we simply go back to 41, which is another statement of the principle of indirect discrimination. Nowhere do we see this is not direct discrimination, or there is no direct discrimination here, or even one does not analyse a residence test in this way, or even one must analyse a residence test in this way. We simply see an acceptance of the first limb of the appellant's case. Why? Because the Belgian state had conceded it at 45. And in fact, 42 to 44 simply deal with whether or not there's a difference in treatment.
Where is it made plain that they failed the principal residence test?
Because they challenged it.
What?
I say it's plain enough because they challenged it. Because they challenged the principal, because the parties challenged the principal residence test. Yes, and we can see that, for example, from 42 and 43, where the distinction identified is those who do not satisfy those conditions. So we see in 42, in the case in the main proceedings, the decree of June 16, 2006 provides unrestricted access to courses. That is, those who satisfy both the requirement that their principal residence be in Belgium and one of the 8 other alternative conditions. The students who do not satisfy those conditions, by contrast, enjoy only restricted access to those institutions. Now, if the case had solely been concerned with the second set of conditions, the 8 alternatives, there would have been no reference to the first. There would have been no argument about the first. So it's because the students failed the principal residence condition that they needed to address all of them.
I'm reluctant to remind my friend there were 2 actions, one by students and one by lecturers at 23.
Yes? But this case, therefore, arises in quite different circumstances. Now, this may not be the explanation. There may be another explanation. I can't say with any confidence what the explanation is. But what I would submit that the court can't with any confidence, this court can't with any confidence accept that this is a holding that one doesn't examine conditions separately, or that there is only indirect discrimination and not also direct discrimination in cases such as these. with any confidence. But I still go further than that, and I say that it is significant that there is no case in which the Court of Justice has been presented with an argument for direct discrimination and rejected it for conditions like these. The Court of Appeal didn't accept that any of the cases relied upon showed that, and your lordships weren't taken by my learned friend to any of the cases, apart from what he accepted was a rather short line of cases, Bidar and Bressol, neither of which the point was argued or raised by the parties, and in Bressol only raised by the Advocate General. Now, in my submission, it is open to your lordships to ask the Court of Justice the question that Advocate General Sharpston posed for them in this case. I don't say that your lordships lack the discretion to do that, even if I were right that it were at clear, your lordships would still, in fact, possess the discretion to ask them that question. But I do say that the answer, if it's that for which my learned friend contends, unless it's to be qualified or limited in some way that hasn't been articulated to this field, is a radical change for the law of discrimination. So in short, if the requirement were truly, as my learned friend has sought to characterise it, one of social or economic integration, well, why, it could be failed, surely, by a British or Irish citizen. Surely, if Miss Patmalniece, surely if a British citizen comes here, never having been here, having no other connections with the United Kingdom, arrives for the first time, surely this supposed condition of social and economic integration could be failed by them. But not so, as I've shown you from my learned friend's note, and has always been accepted, and is accepted in the Statement of Facts and Issues. It can't be failed because it's not a condition of social or economic integration. It's a condition of having a right to reside. Now, it might be that in European Convention law, European Convention on Human Rights, that might be an acceptable proxy. But it's not under European Union law acceptable to have a directly discriminatory proxy. And that is settled. Now, the second consideration, and this is complementary to the first of the arguments on it, is whether or not this measure is justified by considerations independent of nationality.
Yes.
And I've taken your lordships to the Statement of Facts and Issues, which is agreed, and where it's accepted that that's a requirement. Paragraph 26.
26, yes.
It's not justified by proportionate considerations, or even justified by a legitimate aim proportionately effected. It's got to be considerations independent of nationality. I made my submissions in opening on why that fits with what I say about direct discrimination. Now, in the Statement of Facts and Issues, which your lordships will appreciate, signed by my own friend, paragraph 33, and this is in the list of agreed points, not because we accepted that it was independent of nationality, but because it was agreed that this was the justification he was advancing. The Secretary of State said that the justification he advanced for the discriminatory effect of Regulation 2 is to protect the resources of the United Kingdom by refusing means-tested benefits to non-economic European Union migrants who cannot support themselves, and that there is a principle of European Union law that member states are entitled not to grant social assistance to non-economically active nationals of other EU member states. Now, we said in our printed case, that's dependent on nationality. That's not independent of nationality. It only relates to people who aren't British or, as it happens, Irish. Now, my learned friend moves away from that wording, doesn't seek to confront the case in our printed case. He instead seeks to reformulate his justification in a way which, at least apparently, is independent of nationality. And he does that in his case at page 25. I could ask your lordship to turn there.
Page 25?
Page 25 of the respondent's case, my lord. And for the first time, he says, that the measures seek to identify either economic integration or a sufficient degree of social integration, open brackets, an objective which applies equally to UK and other EU nationals, and indeed to nationals of third countries. Now that's an interesting phraseology, because it rather seems to, doesn't in fact say that the justification for these measures is the social and or economic integration of UK nationals or nationals of third countries. And it doesn't sit, of course, happily with the contention of law in paragraph 57 at the end. Member states are not, however, obliged to provide assistance to nationals of other EU member states who are not economically active and have not established the requisite degree of social integration in that member state. Nor, of course, does it sit happily with the contention in relation to the Irish, page 34, paragraph 69, D, that the purpose of the reference to Ireland was to extend more favourable treatment to Irish nationals. Now, I don't want this to be a...
Which paragraph was that?
I'm so sorry. Page 34, paragraph 69 at E. This isn't a pleading point, and I don't want it to be thought to be one. Quite happy for Mr. Lewis to change his mind about what the Secretary of State's justification is, and to show your lordships the material in which that justification is set out, and if your lordships take the view that he wants to express at the hearing or in the respondent's case as to how that should be viewed, so be it. Your lordships are entitled to agree with him. So we must look then at the material about why the Secretary of State introduced the test. And in my submission, it's absolutely clear that on the material before the court, the function of the right to reside test was solely the exclusion of European Union citizens other than British and Irish citizens. Not, of course, the exclusion of all such non-British Irish EU citizens, but only persons of those nationalities. It was simply not concerned with people who were not European Union citizens, and it was simply not concerned with having any effect on British or Irish citizens. Now, if I could just take your lordship back to some of the material that the Secretary of State put before the Social Security Advisory Committee, and he made two statements to them. He makes an initial statement telling them about his proposals, and then he makes a final statement responding to their report. And I just want to take your lordships first to the initial statement, which is it's in the appendix, page 84.
84?
84 of the appendix of paragraph 2.
Yeah.
Paragraph 1. The Department has been considering the effectiveness of the habitual residence test in protecting the UK benefit system from exploitation. And then there's a reference to the expansion of the Union that's coming into effect on the 1st of May 2004. And then 2. At the same time, the government recognises the need to safeguard the UK social security system from the possibility of exploitation. It therefore announced on the 23rd of February specific measures to close off the option of people. And that's a word that gets repeated a lot in this, but we need to explore what people means. People coming to this country, not to work, but to claim benefits. These measures put into UK social security law the principle that EU citizens who move around the European Economic Area must generally be able to support themselves, which is already set out in current EC Rights of Residence directives. This memorandum sets out in detail the new regulations and administrative procedures that will implement this change. And this is the memorandum that accompanied the draft habitual residence regulations, which were made in exactly the form that they were originally drafted. So I say that makes the object plain. People means EU citizens coming from other EU countries, not our own. Now, I showed you in opening that Parliament had precluded access by non-EU citizens to social security benefits unless they had leave to remain here by section 115 of the Immigration and Asylum Act 1999. And that came into force in 2000. In fact, similar steps had already been taken by regulations, but it doesn't matter for present purposes. So 4 years before, Secretary of State, Parliament had put on a statutory footing general prohibition, or rather a general requirement of right to reside for persons who are not EU citizens. This proposal made no difference to those third country nationals, those people who are not EU citizens. They already had to have a right to reside. It made absolutely no difference to them at all. There's nothing to indicate in the papers, and you haven't been taken to any indication, that those people were thought to be a proper target of this new regulation. It was unnecessary, superfluous for them. The second point is, it's quite clear that this was not intended to impose any additional burden on UK citizens. Firstly, because of the 1999 Act, if you want to get benefits, you need to show your nationality anyway, because you need to show that you're British or otherwise EU. If you simply turn up at the job centre and assert that you're British, the job centre asks you to prove your nationality, because otherwise you might be somebody excluded under section 115. So from the year 2000, it was already always necessary, for practical purposes, to prove one's citizenship. The point is that it was enough to prove one's citizenship if one was habitually resident. What changed in 2004 was that was no longer enough unless you were British or Irish. And we can see that at the only point made about British citizens in the opening statement to the Social Security Advisory Committee at page 88, paragraph 13. UK nationals will need to be able to show that they have a right to reside before they can have access to income-related benefits. They have a right of abode under the Immigration Act 1971. Evidence of a passport or birth certificate should generally suffice. And that's third country nationals will in general need to show that they have a right to reside in the UK before gaining access to the income-related benefits. Under section 115 of the Immigration and Asylum Act 1999, most are excluded from entitlement. Those who are subject to immigration control will, as now in general, continue to have no right to income-related benefits, so will continue. Small groups of third country nationals are not subject to the exclusion, and that will continue. These include A, people who have been granted limited leave to enter or to remain. So pausing there, they have a right to reside, and who are temporarily without funds because remittance to them from abroad has been disrupted. B, people who have been granted leave to enter or remain as the result of an undertaking, so they also have a right to reside. And nationals of countries which have ratified the European Convention on Social and Medical Assistance on the European Social Charter who are lawfully present in the UK. I'm not aware of that, the application of that rule to state pension credit, nor am I aware of that continuing to exist for any class of persons except those covered by the EU accession regulations, but I'm quite happy to.
We've not seen this group before, I don't
No,
think.
I'm quite happily. I think Lord Brown saw them in Soma, where there was a Polish national, but I don't think that from 2004 there were any residual nationals of those countries who were not joining the EEA states, but I'm quite happy to be put straight on that. And this was noted by the Secretary of State also. These points were noted in his concluding statement after considering what the committee had said at page 60.
60. Is it, we're going back to...
I'm going onwards, as it were, in time.
Yes, but back
to his
in the
concluding statement, back in pages, to page 60.
Right. No, I don't think we've seen this document before.
I think your Lordships have. It begins at page 55.
Yes, we have. Yes, I beg your pardon. Yes, we looked at 60. Yeah. Yeah. Just put a tab in it.
So in this, the Secretary of State essentially says, thank you for what you've said about the regulations. I'm going to make them in the form I proposed, and here's why. And of course, your Lordship will see nowhere in this any debate about the effect on British citizens, or Irish citizens, or third country nationals. So we see at 43, as the committee notes, access to benefits is already controlled for third country nationals. In essence, only those with a right to reside in the UK are entitled to claim the income-related benefits. The committee's concern revolves principally around other EEA nationals. Well, of course it does. It didn't, in fact, principally revolve around them, it entirely revolved around them. In particular, those who are economically inactive. Now, when the government then continues to say in 45, as already explained, the government considers that it is not unreasonable to concentrate benefits on people who have a particularly close connection with the UK, or to expect people to have a right to reside in the UK. The only additional requirement is that the people are citizens of EU countries other than the United Kingdom or Ireland. Now, just to take your Lordships to the last couple of references on this over the page at 62. Under the heading Compatibility with EU law, at 58, moreover, the new requirement to have a right to reside in the UK as a condition of access to income-related benefits will apply to UK nationals as well as current EEA nationals and nationals of the acceding states. No reference to other people there. It will thus apply equally to nationals of all member states. Well, that's for your Lordships to evaluate as to whether or not it, in truth, does apply equally to British citizens as it does to citizens of other European Union countries. If it does apply equally, it's not even indirect discrimination. It's just not discriminatory at all. But my submission is, of course, it doesn't apply equally because they need to do more than a British citizen. And we see lastly the reference in 61 in the conclusions section in relation to the committee's conclusions. 61, provided claimants are habitually resident, there is nothing at the present to prevent those from other EEA states, current as well as new, from claiming income-related benefits without having a right to reside in the UK. Here we see the real meaning of people. The government has been concerned for some time that some current EEA nationals, and by that it means members of the 15 states before the accession of the 10 states that acceded in 2004. Current EEA nationals have taken advantage of free movement within the European Economic Area to become an unreasonable burden on our benefit system, even though this negates their right of residence in the UK. We believe that it is reasonable to expect people to have a right to reside in the UK before they can have access to the income-related benefits, particularly as support may last for many years. What the Secretary of State's memorandum doesn't recognise or address, despite the immediate concession by the Secretary of State when these proceedings were launched, was that this measure discriminates against those people. So we see incompatibility with EU law at 58, the simple assertion that it will apply equally, and an assertion that's never been repeated in these proceedings. It's accepted that they apply unequally. The only question at the moment is whether or not that's direct discrimination, and here, whether the justification advanced is independent of nationality. So in my submission, the rationale is not, as was suggested at the beginning of my Learned Friends submissions, people coming here to claim benefits and not to work. The rationale is non-British, non-Irish citizens who do not have a right to reside. And in fact, in answer to a question from my Lord Brown about the application of the rules to people like Ms. Zalewska, my Learned Friend amended the justification so that it didn't only catch those who've come here to claim benefits and not work, it also catches those who've come here to work and then have stopped working and are in what he called involuntary unemployment.
Voluntary.
I'm so sorry. I'm stand corrected. Voluntary unemployment. And so we see that this test of economic and social integration is failed by Miss Kaczmarek, who came here as a student and then found a job, and then only fell out of the labour market because her child was sick and she couldn't afford a childminder. She's not economically and socially integrated. Why? Because she doesn't have a right to reside. And I've placed on your Lordship's desk a case, and I do this rather than go through in detail the caveats that can be entered about the rights to reside, simply to demonstrate to your Lordships the breadth of the cases with whose of the persons whose rights your Lordship's judgment will determine. It's not just Miss Patmalniece and Miss Kaczmarek, and as we'll see, Miss Zalewska. It's also Miss JS. It's a decision that looks like this. This is a very recent decision of the upper tribunal. I'm told that Miss JS is seeking to appeal. Has got permission to appeal. Mr. Drabble appeared for Miss JS. We see in paragraph 1, this appeal principally concerns what impact, if any, the law of the European Union has in relation to a national of a member state who comes to the UK, works, begins a course of study, becomes pregnant, works again, and who then, finding that in the later stages of her pregnancy she is unable to continue working, claims income support. And the short answer is, she loses her right to reside, because the upper tribunal's determination is that women who are incapable of work through pregnancy have no right to reside, even though they've worked. That's the social and economic integration test in action. That's who loses. We can see that very quickly. The detailed facts are set out at paragraph 5, over the page. Came to the UK, French, came to the UK on the 10th of July 2006, worked for the best part of a year, mostly as a teaching assistant, then enrolled for a PGCE, but we can see just at the hole punch, the top one, she became pregnant, the expected date of confinement being 2nd of June 2008. Realising that she would have given birth prior to the end of her course, she withdrew from her studies. Her bursary payments ceased. She undertook agency work, hoping to find teaching assistant positions in secondary schools. None was available, so she took agency positions working in nursery schools. By 12th of March 2008, the demands of caring for nursery school children while some 6 months pregnant were proving too much, and she stopped such work. The claimant looked unsuccessfully for lighter work for a few days before giving up doing so, and on the 18th of March 2008, claiming income support, which was refused. And the judge decided that she was not a worker, and we see that over the page at paragraph 14. Because we see at paragraph 14, so 2 paragraphs up from the bottom, under the heading Regulation 16/1268. Not in dispute, she was not looking for work. Due to her pregnancy, she considered she was not in a position to accept any offers of work the agency might have made to her. Mr. Drabble, consistently with authority, does not seek to argue that the wording of Article 7.3a applied to the claimant. That's the definition of retained right of worker when the person becomes temporarily incapable of work. She could not be said by reason of pregnancy alone to be unable to work as the result of an illness, nor was the inclusion of pregnancy to be implied. Now, of course, the correctness of that decision is not before your lordships, but it is an example of what a right to reside, of the limitations on the rights to reside. I should just mention that, of course, my own friend Mr. Drabble reserved the argument that's now being advanced before your lordships.
Notice. No surprise there.
No surprise there. But my friend Mr. Lewis, quite rightly, doesn't suggest that the result of the decision in this case turns upon the fact of Miss Patmalniece, because he doesn't suggest that the issue is whether it's... He doesn't actually argue that the issue is whether or not discrimination is justified, because that isn't the issue. The issue is whether it's independent of nationality. My lords, it's been said that the reason that the Secretary of State drew the line at the right to reside was because it was striking the balance. On my submission, the reason that he drew the line at the right to reside was because he knew that if he drew it any more narrowly, he'd breach Article 12 of the treaty. So, in fact, all the Secretary of State has done is protect those people he already accepted he was bound by community law to accept. Now, the question is he also bound to accept by community law persons who fall within the scope of Article 3 of Regulation 1408/71? It's common ground that the scope is different. Article 12 only applies to persons who are lawfully resident. Lawful presence isn't sufficient. It's common ground between myself and Mr. Lewis. Lawful presence isn't sufficient. But that doesn't matter, because lawful residence isn't a requirement of 1408/71. It's accepted that we're within the scope of 1408/71. And that's Mr. Lewis's real problem. He can't locate anywhere in the text of Regulation 1408/71, or anywhere in the text of the treaty, a distinction grounded in lawful presence versus lawful residence. Regulation 140871 is expressed to apply to everybody within its personal scope without distinction. 140871 doesn't distinguish between on grounds of residence. And my friend Mr. Lewis, when reading out the recitals, I asked him to read out the recitals that referred to without, that spoke of without regard to the place of residence. So he can't find it anywhere within 140871. He can find a distinction between hybrid benefits and other benefits, though he can't explain why the Secretary of State has prohibited entitlement to child benefit, which isn't a hybrid benefit. But he can't find any way to give effect to that distinction with reference to the rights to reside of the persons under 140871. He says it's just obvious. He says it comes from the purpose of Regulation 140871, but he can't find any cases or cite any recitals that draw the distinction. Can I just deal with the case of Zalewska, which is at volume 3, tab 43. If your Lordships would turn to the issues as framed by my Lord Hope at page 2611 in paragraph 22. The central issue is whether the registration requirements in Regulation 7 of the 2004 regulations, now pausing there, that was the requirement of an accession state national subject to registration to register that employment under the accession regulation, on which the appellant's right to reside in the United Kingdom under the worker registration scheme depends, are compatible with community law. And we'll now see that two aspects of community law were relied upon. The appellant, Mr. O'Hara, said that her primary argument is that she is entitled, relying directly on Article 39 of the treaty and Article 7.2 of Regulation 1612/68, to the same social and tax advantages as workers who are nationals of the United Kingdom. So pausing there, that was a discrimination argument, the same social and tax advantages. If this argument is right, any failure to comply with the registration requirements must simply be disregarded. The second argument is that the right to reside test, which is linked to the requirements to register the initial employment and to re-register all subsequent changes during the first 12 months, is unnecessary and disproportionate. And note, not discriminatory. So the first argument was, I am protected from discrimination. The second argument was, if I'm not protected from discrimination, if I'm subject to the derogation, then the discrimination must be effected in a proportionate way. Now, the first point failed, and on this, all of the judges who took part in it were agreed, because the appellant was outside the scope, the personal scope, of the prohibition on discrimination. You can see that in paragraph 25. The first question is whether the appellant can rely directly on Article 39 and Article 7.2 of Council Regulation 1612/68 to qualify for income support, despite the fact that she was not authorised to work for an authorised employer under Regulation 7 of the 2004 regulations for the whole of the 12-month period. In my opinion, the answer to it is to be found in paragraph 2 of Part 2 of Annex 12 to the Act of Accession.
So she failed because she was outside the scope of what?
She fails because she's outside the scope of Article 7.2, because she was no longer a worker. So, as in my submission, my Lord Hope goes on to explain. So in order to fall within 7.2, she needed to be a worker. Sorry, can I just take your Lordships to 7.2 just to see that? If I could.
Can I quote it somewhere?
It's at 2606 at paragraph 6 at E.
Yeah.
So it's the article, just up from there actually, at D, Title 2, Article 7 provides for the equal treatment of workers who are eligible for the right to take up of an activity as an employed person under Article 1. 1. A worker who is a national of a member state may not, in the territory of another member state, be treated differently from national workers by reason of his nationality in respect of any conditions of employment and work, and so on. And then paragraph 2, he shall enjoy the same social and tax advantages as national workers. Now, unlike so many other people here, I wasn't involved in Zalewska, so I don't know whether there was a subordinate argument from the Secretary of State to that, but it would appear not from paragraph 22 of my Lord Hope's reasoning. It would appear that if the appellant had been able to establish that she was a worker, despite not having registered, she would have been home and dry. So the reason that she wasn't a worker is to be found in if we could just turn back to page 2612, paragraph 26. Absent the derogation provisions in that paragraph, a worker who is a national of any member state has the same rights of access to labour markets and to the social advantages that go with it as to those of any other member state. And then we see down at H, the effect of that paragraph, and that's the derogation paragraph, was to enable the United Kingdom, notwithstanding the fundamental rules of community law as to freedom of movement of persons, to lay down its own rules for access to its labour market by A8 state nationals.
So that's the effect of the derogation for the Article 8, for the A8 nationals.
Yes. And then in 27, it is true that paragraph 2 does not mention Article 7 of Regulation 1612/68. In other words, there was no express derogation from Article 7. And then my Lord Hope explains over the page, in second line down, I think there are two reasons for the fact that Article 7 is not mentioned. The first is that mention of it was unnecessary. Access to labour markets is treated in Title 1 of the regulation as a question of eligibility. The fundamental rules about the eligibility for employment of any national of a member state are set out in Articles 1 to 6. A national of a member state who takes up employment in another member state under those rules is a worker for the purposes of Article 7, but not otherwise. Taking Poland as the example, displacement of Articles 1 to 6 by national measures was all that the derogation provision in paragraph 2 needed to do to ensure that access to employment in the 15 existing member states by workers from Poland was controlled by national measures. The second is that its exclusion from derogation ensured that any workers from Poland who did obtain access to the labour market in an existing member state under its national measures enjoyed the same guarantees against discrimination as regards conditions of employment and social and tax advantages as national workers. But the rights conferred on Polish workers by Article 7 were to depend on their compliance with the national measures. In other words, to be a worker, to be within the personal scope of Article 7, one needed to comply with the national measures. And that's because there was a derogation from Articles 1 to 6. So in my submission, the reason that Ms. Zalewska's discrimination claim failed is because she was not a worker within the special meaning given under the derogation provisions, and therefore did not fall under Article 7. There is no derogation from Regulation 1408/71. There is no argument before you that Ms. Patmalniece is not an employed person under Regulation 1408/71. It's quite the reverse. There is a finding of the first-tier tribunal and a consistent acceptance by the respondent that the appellant is an employed person under Regulation 1408/71. So this is a quite different argument from that in Zalewska. Now, my learned friend took your lordships to passages from the judgments on proportionality. There's nothing in my submission in any of those judgments to indicate that it was suggested that this measure was concerned with anybody except EU nationals. But of course, when your lordships were looking at whether or not it was proportional, the court was not looking at whether there was justification independent of the nationality of the persons concerned. There didn't need to be, because the question was whether the derogation had been effected in a proportional way. The derogation is discrimination on grounds of nationality. It's an exception to the prohibition on that discrimination. But what your lordships would need to find here is that at the same time as this being a proportional implementation of a deliberately discriminatory measure, It was also the implementation of a non-discriminatory measure. Well, it isn't. In fact, it can't be both, with respect. The very success of my learned friend, or the very premises of the argument in Zalewska were, this is directed at A8 nationals because they are not British, not Irish, and not already in the EU. Have we done it in a proportional way? Have we gone about discriminating in a proportional way? That was the issue. My learned friend's challenge today is to say, that we went about not discriminating? It's the opposite. So Zalewska doesn't help him at all in my submission. If the Secretary of State has the power to if the Secretary of State had the power to discriminate on grounds of nationality in respect of social security benefits for persons within the scope of 140871, this may well be a proportionate exercise of it. But he doesn't contend that he has the power. He says, and he accepts, that he has no power to discriminate on grounds of nationality. So, in my submission, the answers to the two questions that I posed at the outset of my reply are, firstly, that there is direct discrimination here, and secondly, that the justification advanced is not independent of nationality. And therefore, on the premises of my learned friend's case, as summarised in the statements of facts and issues, he fails. Because he can't justify the discrimination under Article 3.1, not because it's disproportionate, but because he hasn't got over the prior hurdles. And in my submission, that result can be based upon clear principles of community law. In particular, the clear principle, common ground, that discrimination on nationality grounds can only be justified by considerations independent of nationality. This is not a case where your lordships would need to consider, ultimately, the distinction between direct discrimination and indirect discrimination. It's not necessary for your lordship's judgment. Unless your lordships hold, against me, that what has been put forward by my learned friends is not to do with the nationality of the persons concerned, that the measure is motivated by an aim of excluding British citizens from benefits where they're not economically or socially integrated, or Irish citizens from benefits. In my submission, that's untenable. Now, some of these submissions may seem obvious or circular, but in my submission, that's precisely because, when boiled down to its essentials, the case is, as my learned friend said in his submissions, simple. It simply is a case of direct discrimination. It's been obscured by the use of the word people. It's been obscured by the fact that the Secretary of State didn't appreciate that he was bound by 140871 as well as Article 12. But in the final analysis, we've heard no arguments that Article 12 cuts down Article 3. We've heard no real argument that there's a principle of EU law that allows for discrimination against EU citizens in respect of social assistance. My learned friend abjures any idea that there's been deliberate discrimination here. If you're persuaded that that's the true state of affairs, so be it. But in my submission, the true state of affairs is that there is deliberate, calculated discrimination against EU citizens. Not all of them. And it may be that under a different legal framework, it wouldn't be prohibited. But the community has set its face completely against discrimination on nationality grounds. If the Secretary of State wants to restrict benefits by a new social or economic integration test, other than the one that he already has of habitual residence, he must apply it in a way that is equal for all citizens of the European Union. He cannot give British citizens and Irish citizens a free pass, that simply by showing their passport, they qualify. If he doesn't like paying the benefits concerned, then he can ask the Secretary of State for the Home Department to consider removing those people. He now accepts, he hadn't at the Court of Appeal, but he now accepts that he can do that. That's the solution that the Court of Justice recognised in Troiani. But one cannot, as, to use the language of my Lord Brown in argument, one cannot starve out European Union citizens. In fact, one cannot discriminate at all on the grounds of their nationality. My Lords, unless your Lordship would like to deal with anything else, such as the Irish point, I'm very happy to leave my submissions there.
No, Mr Cox, I think we've been helped all
I'm
we can.
grateful.
We're extremely grateful to Council for all their assistance, both in writing and orally over the past 3 days. We will take time to consider our decision.